is now in session.
Please be seated. Good morning. We're here for oral argument in case number CV130257, Timothy Lee versus M&H Enterprises and Walmart. These proceedings are being audio and video recorded, so we ask that you identify yourself and your client at the beginning of your argument. Each side, I think, has 20 minutes. If we need to go slightly over, we may make an exception to that. Appellant's counsel is responsible for reserving any time that you want to reserve for rebuttal. We have read the briefs. We've already conferenced this matter, and we're looking forward to your argument. And you may proceed.
May it please the court, Steve Hopkins on behalf of plaintiff appellant Timothy Lee. I'll try to reserve 2 minutes for rebuttal, and I understand I need to keep track of the time myself. I appreciate the court's providing us with questions beforehand. That makes this a fairly easy process, and it actually dovetails nicely into the points that we were going to emphasize as part of this argument. And so I'll just kind of dive in because I know the court wants to hear the lawyers respond to those 6 questions. The first question that we were provided last week is, does this court's holding in Welker versus Kennecott Copper Company, then the citation, that under the restatement second of torts, section 422, landowners are not liable for injuries sustained by an independent contractor's employees, remain a valid proposition of law? The short answer to that question is that is no longer a valid proposition of law. The Welker case, and I'll talk more specifically about the various and sundry problems with the analysis in that case, but Welker was effectively overruled by the Fort Lowell versus NSSS Limited Partnership case. And that...
Counsel, you say effectively because the Fort Lowell case never mentions Welker, correct?
It never mentions Welker, Your Honor.
But that's a completely different scenario with a business invitee, isn't it? Why does that necessarily impact Welker?
Because the employee of a subcontractor, Your Honor, is a business invitee. It's not a trespasser, not a social guest, and we cited cases in our briefs that say an employee of a subcontractor is a business invitee. The Fort Lowell case...
Is there other authority for that? I understood a business invitee to just be someone who's there at the store shopping. Is that different than, isn't that different?
It is different, Your Honor, because there's 3 categories, and again, we cited cases for the proposition that a employee of a subcontractor is included as an invitee, and as the court is aware, there's 3 classes of people on land that the law still makes a distinction for. There's social guests or licensees, there's trespassers, and everyone else, including employees of subcontractors, fits within the broad parameter of a business invitee. And I would just refer the court to the citations in our brief. And I guess apropos to Judge Brown's question, the facts of Fort Lowell mandate that it's a total reversal of Welker, because under the facts of Fort Lowell, you have an employee of a subcontractor, the security system person, who's demonstrating the system and receives a severe electrical shock due to the negligence of another subcontractor, the electrician.
So who was in possession of the property in Fort Lowell?
In Fort Lowell, the owner had assumed possession at the conclusion of the work.
So it's not a contractor case? I mean, it's not a construction case?
Yeah, I think it is, Your Honor, because...
Active construction?
The construction had been completed. Okay. But I think it's...
But Welker and its progeny, and Welker, and there's several cases that actually follow Welker. I think you don't disagree with that. Several cases. Aren't each of those cases construction cases? I mean, active constructions with a general on-site, assuming possession or most of possession of the, as opposed to the situation in the Fort Lowell case. Isn't that a sort of a key factor?
I don't believe so, Your Honor, because 422 of the restatement talks about the two provisions of liability. One is while the owner retains control of the premises when construction is ongoing, and the second is when they've accepted construction or accepted the repairs, as the case may be, after the construction is completed.
Yeah, subsection B.
Right.
Yeah.
What Fort Lowell focused on is B.
It focused on B, Your Honor, but there's language from Justice Feldman. And it's at the very conclusion of the case. For the above reasons, we adopt restatement section 422B without qualification with respect to the liability of a possessor of land for the negligence of his independent contractor when such negligence results in injury to an invitee. And we submit that the without qualification language means without qualification. It doesn't limit it to the employee of a subcontractor. And
But how do the facts of this case fall within B? After he has resumed possession of the land upon its completion, even your contention isn't that the project was completed.
no, we believe that this case is one in which there's liability for Walmart because Walmart was in possession coextensively with M&H Construction, which
That would be A,
that would be A.
but that's not what Fort Lowell, and even the excerpt you just read is just 422B.
True, Your Honor, and if you look a little bit up above that, it refers to a case, Kepke, I'm not sure if I'm pronouncing it right, Koepke. And Kepke was a Division I case, and it talked about incorporating 422A. That was the first time that an Arizona appellate court, according to my research, incorporated or believed that 422 should apply. So Kepke says 422A is the law, and then Fort Lowell makes clear that 422B is also the law in Arizona. And I understand the old cases sometimes made a distinction for employees of subcontractors as not being within that section. We submit that that's antiquated at this point, and that Justice Feldman, in his opinion in Fort Lowell, makes clear that what we want to do in construction cases like this is promote safety and protect the injured workman, which is not doesn't happen if there's an exception for employees of independent subcontractors.
Counsel, what about some of the rationale in Welker that an employee of a contractor, an independent contractor, is going to be presumed to be covered by workers' compensation, unlike other situations where you have a business invitee that may or may not be covered by workers' compensation?
I think that to the extent that's a policy rationale, Your Honor, that has not been the stated policy rationale in this state for a very long time, and I would refer the court to the Inman case, which we cited in our briefs, and also the Tarrant or Tehran case, which says if you're interpreting workers' compensation laws generally, you're going to interpret them in a way to benefit the person who's injured. You're going to liberally construe them if you're talking about a situation when the person's trying to get workers' compensation benefits. You're going to narrowly construe them in situations like the Lent employee doctrine. So the whole concept is there is no public policy in limiting someone to the workers' compensation remedies. And so we submit that rationale from Welker is just inconsistent with the public policy in Arizona as it exists today. Now, Welker was decided almost 50 years ago. The other points I would raise with respect to Welker is the court, in the opinion, admits to being kind of confused and not really having a firm grasp on what the laws of 422 and these related doctrines stand for. The court also reached its decision based upon the first restatement, not the second restatement. We now have the second restatement. And in the Welker case,
But is it section 422, are there material differences between the first and?
there are, Your Honor. And one of the key differences that we would bring to the court's attention is one of the things that they said in Welker is we've looked through the restatement first, not the restatement second. We've looked through the restatement first, and we don't see a single example in which an employee of a subcontractor is the person being protected. Therefore, to the Welker court, that was some evidence that employees of subcontractors weren't the people that were being protected. The current section, 422, example 2, specifically involves a subcontractor. So that rationale of Welker has gone out the door. The court also said, we've looked at a tentative draft of the second restatement, and in the tentative draft, there's a discussion that this applies to employees of subcontractors specifically, and we understand that that's not being incorporated to the restatement second. Therefore, that to the Welker court was some type of legislative history, if you will, that it wasn't intended to cover employees of subcontractors. I would argue that it's just the contrary, that language didn't make it into the second draft, or the draft of the restatement second, rather, because the restatement makes clear it applies to all invitees, and the definition of invitees specifically includes employees of...
You're suggesting that because of example 2?
Example 2, which involved an independent contractor. And under example 2, they said there was no liability, but the restatement doesn't say there's no liability because it's an employee of a subcontractor. There's no liability based upon, possession of the land. But example 2 does specifically involve a employee subcontractor, and that was absent from the restatement first. So we submit that Welker was incorrectly decided even 50 years ago, that the changes that have been made in the law since then, specifically Fort Lowell and others, the Kepke case, effectively overrule Welker. The other thing I'd note about Welker before moving on is the other policy argument they raised in Welker is the so-called Chicken Little concern, the sky's going to be falling and we're just going to be deluged with lawsuits. Over the past 50 years, this court and the Arizona Supreme Court have not given that concern much credence, and they, in any number of cases, have said, it's just a reasonable care standard. If you don't act reasonably, then let's let the jury sort it out. But the concern that there's going to be an avalanche of lawsuits is not something that we're going to use to deny people their right in court.
Counsel, you're not suggesting that Welker is just a one-time opinion. Aren't there several cases, at least, over the past 30, maybe going back a couple of decades, but weren't there several cases that have followed Welker, including the district court, for federal district court in Arizona, most recently in the Rouse case?
The Rouse case does purport to follow Welker. As we've set forth in our brief, we think that the Rouse case is an outlier. It's obviously not authoritative on this court. It was incorrectly decided for the reasons that we set forth in our brief. But my research indicates that Welker has not been cited recently except in the Rouse decision. Does the court have other questions about question 1? Question 2, Lewis versus N.J. Reeby, does it contradict the holding in Welker on 414 grounds or 422 grounds or both? I submit that it contradicts Welker only on 414, because what the Welker case said is we're going to look to 414, the restatement, to find out whether a general contractor has a duty at all. And the Lewis case says, no, you have a duty as a matter of common law. The duty's there. And 414 exists to allow the fact finder to determine whether that duty's been met. So the more control that you have, the greater the duty, and that's what Lewis said. But Lewis was a direct liability case. It wasn't a vicarious liability case. Lewis never mentions 422 in the opinion. It's strictly a 414. Can the employee of a subcontractor sue the general? And the 422 situation, the Fort Lowell situation, is not the contractor necessarily, but the possessor of land. Can the employee of a subcontractor pursue a remedy against the possessor of land based upon a non-delegable duty?
So vis-a-vis Walmart, then the claim against Walmart, Lewis isn't particularly relevant here then.
Well, Lewis is not relevant as to the Walmart claim, except as it relates to retained control, because we do have a retained control argument against Walmart.
Which sort of leads to the next
Right.
question. Next question to the court that we proposed have you sufficiently preserved that argument for us to consider retain control under 414?
We believe you have, Your Honor.
It wasn't. I mean, you didn't cite it in the opening brief. You'll concede that.
Well, we did not cite it in the opening brief. We did not cite that section specifically even in the response to the motion for summary judgment or at oral argument. But the way this, or the reason this hasn't been waived is this was a defense. This was Walmart's motion, and they said, we're not liable under either 414 or 422 because we weren't in possession or we didn't have control. So then Mr. Lyons goes through the evidence that shows there was control and there was possession. Now, he doesn't mention 414 specifically, but he was at that point responding to Walmart's argument. So it was clear in the context, which it was argued, that we were responding to the control issue, which is a 414 issue. And I would analogize it to this, Your Honor. If I were to get up in trial and say, objection, the probative value of this evidence is substantially outweighed by the unfair prejudice and confusing the jury, I don't mention 403 of the Rules of Evidence specifically, but it's obvious that's what I'm talking about. And I think this is a similar situation. It was clear in our response to the motion for summary judgment that we were responding to Walmart's claim under 414, even though at that point we didn't cite the 414 specifically. We just said, here's why there's control vested in Walmart.
And on the issue of retained control, so could you direct, what is your best argument in 30 seconds or so? What is the best evidence that Walmart retained the control?
And I'll cite to the court the places in the record, and then I'll tell you what they say in summary. It's page 42 of our opening brief, page 15, or starting at page 15 of the reply brief, and the reporter's transcript of January 5, 2012, pages 36 to 41. And the evidence was that an Yvette Webb, who was a Walmart employee, described their responsibility as a shared responsibility or a joint responsibility over the job site with M&H Enterprises. She believed that she didn't say more probably than not, but she said probably Walmart had accepted the premises 4 to 5 weeks before Mr. Lee's injury. And it was late in the process. The store's getting ready to open. Walmart had 30 to 40 people on site at the time. That's in the record. Ms. Webb describes that as a joint responsibility, and it was a Walmart person who directed that the work be done at all. The Walmart person went to M&H and said, clean the top of these coolers off. So they're the ones that are actually directing what work gets done or when it gets done. And under 414, as we cited in the brief, Your Honor, the amount of retained control that's necessary to impose liability in 414 is not great. It includes, per the Lewis case, just the ability to say when the work gets done, just to sequence the work, and clearly Walmart did that here. So those are the, I guess the bullet points are the best evidence that we believe exists with respect to the control issue. And just as an aside, I think that the trial court confused possession, which is a 422 issue, with control, which is a 414 issue in reaching its decision. Jumping ahead to 5, since I know the time is running, the significance of the contract between Able Body and Martin Harris. We don't believe it really has any significance because there was no foundation for it. Again, at the oral argument on November 16th, 2010, pages 9 and pages 13, Mr. Lyons indicates to the trial court, we've asked for a contract. We've subpoenaed a contract from Able Body. We've never been provided one. We've got one page of contractual terms that we received a couple days before the oral argument, but that's dated November. That's dated 10 months after Mr. Lee's injury. So there's an insufficient foundation for it as being applicable to this injury. I'd also note for the record, this exhibit was identified as 112. It was trial exhibit 112. It was never offered into evidence. It was never admitted into evidence. But if you read, again, the transcript of January 29th, 2013, when the directed verdict issue was argued, it's clear that the trial court was under the assumption that that was in evidence and that was part of the record. It isn't. Now, having said that, I don't think there's foundation for it. There was never an introduction of it at trial. M&H contends it helps their position as respect to control. I've cited in the brief that argument is basically to the contrary, that we believe to the extent this is a valid and enforceable contract, and it was a contract that existed, which again we don't think it is, it actually shows that Able Body had the right to control the details of the work. I see that I'm out of time, Your Honor. Do you want me to address 6 briefly?
We'll give you one more minute.
Okay. Inman versus Crane Rental Services, the question is, does it stand for the proposition that the Lent employee doctrine applies only if the special employer has workers' compensation coverage for the injured employee? The answer is yes. I think this court said that specifically in Inman 3 different times. I won't read them, but they're paragraph 8, paragraph 12, and paragraph 14, and the end of 14, actually I will read. It says, applying this required standard and interpreting the Act prevents us from adopting an interpretation that would grant immunity from suit under the Act without a corresponding obligation upon the immunized party. So my interpretation of Inman is that it pretty clearly says if you don't have the obligation to pay workers' compensation, then you can't enjoy the immunity. It's a quid pro quo.
I mean, are you suggesting that M&H was not on the hook for workers' compensation here?
I am, Your Honor.
I mean, a claim could not have been brought against them?
It absolutely could not. And here's the reason. And this is why this defense, without getting up on my soapbox, is so insidious as it relates to an injured worker. The lawsuit was filed close to the year anniversary. After a year passed.
Okay, why couldn't they have been named just to cut to the chase, why couldn't they have been named in the original notice of injury or claim of injury to the workers, to the Industrial Commission?
They could have been, Your Honor. Was it possible to make a claim against them? It was, but no one thought that they were responsible. And I would also note that it was also very possible for M&H to come forward and say, we admit we're responsible. We'll share in these, all these medical expenses because we're a co-employer. They didn't do that. I mean, under 23-1061, there's a 1-year limitation to make a claim. So by the time that M&H raises this defense that we're the statutory employer and we're entitled to immunity, it's not possible at that point to make a claim. And that's another reason that we submit this simply isn't fair to the injured worker.
Would the claim be for any greater amount based on the fact that there's 2 employers rather than 1 employer?
No, I think the way it would work is there's one injury, there's one series of medical expenses, they would be shared equally from the 2 employers, but that wasn't done here. And that's.
But isn't that then a matter between the 2 employers as opposed to your client doesn't necessarily, it doesn't change the amount that he would get?
It doesn't change the amount he would get, which is probably the reason that claim was never pursued. I was not his workers' compensation lawyer at that point. I was not, involved in the case at that point. But if he has workers' compensation insurance through Able Body, there isn't really any reason to pursue a claim against M&H. But again, M&H also never volunteered
It
to.
would sort of, so then me, that it's puzzling that Inman would make the statements that you have to carry insurance. I mean, if there's two employers, why do both employers have to carry insurance as long as they're liable for the workers' compensation claim, and which is what Larson says.
Well-
You won't disagree that Larson says it's liability for the claim, not actually carrying the policy.
It is liability, Your Honor, but I think the cases pre-Inman indicate that who paid the premiums or who paid the workers' compensation is a factor in who really the employer was.
Understood.
Yeah. Thank you.
Good morning. May it please the court. I'm Douglas Fitch, and I represent Walmart. We're going to try and reserve 10 minutes for M&H's counsel. Let me just delve right into the questions. Number one, Welker is still valid in this state. We are taking the position diametrically opposed to the appellant. And there are a number of cases that have had the opportunity to change it if it was incorrect. They haven't. The most recent of which, at least that's been cited by the parties here, is the Fort Lowell case. Fort Lowell did not deal with the employee of an independent contractor. It dealt with the employee of the owner of the property that had work performed at the property by an independent contractor, which then led to the injury. That employee fell into the others category discussed in the restatement second, section 422, where invitees would reside, where customers of an employer, and Kepke is a good example of that as well. Kepke involved an injury taking place at a retail establishment, work being done by an independent contractor. A chalk line resulted in a tripping injury of a customer of Carter Hawley Hale. And 422 also applied in that case as well, because that was an innocent third party, not an employee of an independent contractor, asserting a claim against the possessor of the property. Welker is different. Welker is dealing with the employee of an independent contractor wanting to assert a claim against the owner or the possessor. And 422, as well as other portions of the restatement, deal with vicarious liability, exceptions to the independent contractor rule, and Welker says those don't apply. There are other instances where the non-liability, the independent contractor non-liability theory has also been carved away, unreasonably dangerous activities, as well as in instances of direct negligence. And 414 applies to those. That's what our motion at the trial level was based on, section 414 of the restatement. Welker was and is directly applicable to that case, as is the Maders case that we cited, as is the Rouse case. The Supreme Court in Lewis did not address whether the vicarious liability exceptions to the independent contractor rule remained the law of the case. They dealt with 414, not 422 at all. So our position is that Welker was and is the law of this state. There are several cases that have reaffirmed that. They are as recently as Fort Lowell. They are the Lewis case. They are the Maders, well, actually the Maders case doesn't reference it, but there are several others cited in the Rouse opinion of Kepke, as well as Parks v. Atkinson and Allison Steele versus Superior Court, all of which talked about different instances which took it outside of the realm of 414, or they applied the exact same set of circumstances that were applied in Welker.
Counsel, what about Mr. Hopkins' argument that the Welker case was decided under the first restatement, not the second?
As it relates to 414, there's no appreciable difference between the restatement of torts and the restatement second of torts. Section 422 did change, but cases dealing with the restatement second version, when given the opportunity to reverse direction taken initially by Welker, chose not to do so. They deal with injuries to innocent third parties. And 422 certainly does apply to those instances. In a case of active construction, ongoing construction, involving injuries of an independent contractor, the law has not changed since at least 1965. And there have been opportunities for it to change, and it hasn't. The second question concerns whether Lewis contradicts the holding in Welker on the restatement of torts, section 422. I would submit it doesn't, because it doesn't even deal with 422 in either iteration. And I do agree with counsel for appellant that it does clarify, if you will, the effect of 414 as it relates to whether or not it defines a duty as opposed to the scope of the duty. The Lewis court said it deals with defining the scope of the duty. A general contractor has a duty of reasonable care. The question becomes whether or not they retain sufficient control over the activity for it to translate into liability. And so I would submit that Lewis is actually a clarification of what initially was stated in Welker. As far as whether the appellant has waived its arguments as to 414, I would submit that it did. At the trial level, it was an apples and oranges sort of argument. We presented a motion for summary judgment based on 414. The response was focused exclusively on 422. There was no effort at the trial level to deal with 414 head-on, citing facts that would, even if you were to assume for the sake of discussion that 414 applied, there still was a factual dispute. That was never done at the trial level, and it was not raised in the opening brief, and it's our position it's been waived. As far as the remaining question, if we were to assume that it is appropriate to discuss whether 414, there is any evidence in the record that would create a factual question requiring a reversal of the summary judgment ruling, we would submit that there is none in the record. Indeed, on page 38 of the opening brief, counsel said Walmart did not control Mr. Lee's work. We agree with that. This case is about whether they retained the right to control Mr. Lee's work. Mr. Lee, in his opening brief, has conceded they didn't. 414 doesn't turn on possession of the property. It turns on retained control, the right to control the work of the independent contractor.
Just for clarification, is it, I'm really splitting hairs here, but is it the right to control or is it actual control?
Well,
Because I know and you know where I might be going here is the lent employee doctrine. The third prong seems to be under word right to control. I know that's not your issue, but right to control. And it was my understanding that 414 was more directed towards actual control, the details of the work.
yes, 414 concerns whether you have retained the control of any part of the work, and there are two prongs to that consideration. One is there contractual provisions that reserve that right, and in this case there are none. We submitted the contract between M&H and Walmart to the Superior Court. It's referenced in our statement of facts. And then actual exercise of control over the subcontractor's work. That's the second prong. And Mr. Lee, as I stated before, has admitted no one from Walmart controlled his work. There's no evidence that Walmart ever went out there and, for example, said, Mr. Lee, we don't like the way you're doing your job. You need to do it this way. The contract didn't afford them that right, and they never took it upon themselves. There's no evidence that they did, that they stepped into an active construction project and exercised control either over Mr. Lee or, for that matter, anybody working for Able Drywall. So we would submit that the trial court got it right. This was and is a 414 analysis. There is no factual dispute as it relates to applying the law to these facts under Section 414. Summary judgment was and is appropriate, and it should be affirmed on appeal. Any effort to try and shoehorn this into a 422 analysis is literally just arguing correct law, but in the wrong set of circumstances.
Let me understand that, if you could say that again. Sorry. You're suggesting, so are you suggesting that Welker's 422 analysis is not relevant here?
Welker's 414 analysis is relevant.
But why not
Welker said that 422, as well as other vicarious liability exceptions to the independent contractor rule, don't apply to injuries suffered by an independent contractor's employee. That was the ruling in Welker, and
Right,
it
they
remains
don't
the law.
apply, saying that a contractor of an employee of an independent contractor cannot sue the landowner under 422 when there's an injury such as happened here. Is that, what am I missing there? Or what does Welker stand for with regard to 422?
That it does not apply to a factual set of circumstances involving injuries by an employee of an independent contractor against the owner of the property.
When you say does not apply, then there's no liability?
If there is liability, it has to be seen through the lens of direct employer, direct owner liability. That body of exceptions to the independent contractor rule. The body of vicarious liability exceptions to the independent contractor rule, they don't apply when you're dealing with an injured employee, an employee of an independent contractor who's been injured. Thank you.
Good morning. May it please the Court, Jim Kloss for Appley Martin Harris Construction. I obviously have some limited time being tail end Charlie here, so I want to get right to what I see as the crux of the issues pertaining to the Court's question and the key issues pertaining to my client's part of the appeal. First of all, on the able-bodied Martin Harris Construction contract, Mr. Hopkins is correct. Because it was a directed verdict, we didn't get to my client's case. It's not a key issue. It's not a determinative issue in any way. It was merely more evidence of the right of control, which, as Judge Brown points out, is the key to our issue. It's not a key piece of evidence. It was just more evidence of the right of control. So whether this Court considers it or not is not really determinative of my client's appeal. The second question on concerning the Inman case. The Inman case is very important, and Mr. Hopkins' concessions right at the end are very appropriate. Mr. Hopkins was absolutely correct on the law when he said that it is whether there is potential liability, whether a workers' compensation claim could have been brought. He was absolutely incorrect in his earlier statement when he said that it must be brought. That is directly contrary to the statements in Inman, and it's directly contrary to the cases before Inman. And despite their argument that somehow Inman changed the law, it is directly contrary to cases of this Court post-Inman. Inman stated, quote, once the special employer is obligated to provide workers' compensation coverage to the LEN employee under the doctrine also extends immunity to the special employer from suit brought by the LEN employee. Obligated to provide is Inman's statement, not payment, not actual provision. the obligation to provide. If an employer is deemed to be a special employer, they are an employer under ARS 23-1022A and therefore obligated to provide benefits. Whether the employee actually makes a claim or payment is made is irrelevant. That is established by cases of this court prior to Inman, Nation v. Weiner, which specifically stated that a plaintiff cannot gain the right to sue simply by foregoing their available workers' compensation rights. Otherwise, we could have that in any employment situation. An employee could get hurt on the job, simply say, well, I'm not going to make a claim, and therefore I get a right to sue. You don't get to do that. Post-Inman, the Schwager versus VH acquisition case at 213 Arizona 414, one of this court's cases in 2006, 3 years post-Inman, made the same statement. Whether there's an actual claim or actual payment is irrelevant to the applicability of the Len employee doctrine. Whether there is any anything in the record about benefits is also irrelevant, as stated by both the Schwager court and also Wiseman versus Dinah Air, cited in our brief. In neither case is there any record of the situation regarding the special employer's workers' compensation situation, because it goes back to Inman, and once the incident occurs, if the Len employee doctrine is applicable, the obligation to provide benefits kicks in, and thus the protections also of exclusive remedy kick in. The key issue, as framed at time of summary judgment and at time of directed verdict and on appeal for my client, is that third element of the word case, the right of control. Plaintiff's arguments in the trial court were quite consistent on their attempt to rebut the right of control. They consistently made two arguments throughout the trial court level. Their first argument was that able body had control over Mr. Lee at the time of the incident. The trial court record is replete with their arguments about what able body could or couldn't do, what safety equipment they provided, what instructions they could provide, the fact that they made payments of wages. All of that is irrelevant, of course, to the right of control. As this court stated in Nation versus Weiner, the employee can have two actual employers. So the fact whether able body may have also been an employer in the technical legal sense at the time of the accident is irrelevant. So their first argument is and always has been irrelevant. Their second argument, consistently made again, was that Martin and Harris did not actually exercise control. And as Judge Brown pointed out, and has been consistent in this court's opinion, actual control is again an irrelevant consideration for the Len employee doctrine. In Word versus Motorola, the Supreme Court told us that it is the right of control that matters and actual control is irrelevant. This court's opinions have consistently upheld that. And again, Nation versus Weiner stated that it's the right to supervise, not the actual exercise of that right, that matters. In this case, the only supervisors on site were Martin and Harris supervisors. There were no able-bodied supervisors on site. Going back to the trial court, interestingly, we do agree that there was error in the trial court. The error was made at time of summary judgment. When Judge Brain granted the directed verdict, interestingly, he apologized to me and my client, saying this case should have been tossed on summary judgment. We should not have incurred the significant fees and costs of further discovery and trial. And Judge Brain is correct. If we look at the history of this court with the Len employee doctrine, we see something that's extraordinarily consistent. We have the Lindsay versus Bucyrus case stating, quote, the usual rule in cases involving labor contractors is that the employer obtaining from a labor service like Manpower assumes the status of special employer and is immune from tort liability. This court has been very consistent on that. Lindsay versus Bucyrus, Nation versus Weiner, Wiseman versus Dinah Air, Schwager versus VHS Acquisitions, Ariaza versus U.S. West. 5 cases where summary judgment was found to be appropriate under a labor contractor case. Mr. Hopkins, I invite him to stand up before you and cite a single case going the other way. There's not a single case ever going the other way under a labor contractor case. Able body in this case is the same as those other labor contractors. The other cases were manpower cases. They were temporary nursing service cases like Medox. Able body is the same type of business, and it's the same type of result that is appropriate here. Finally, we also make the point in our brief, which I don't think is a key point because I don't think we ever get there. But there also was no duty and no breach here. Even if we could get to it, even if we could get past the Len employee doctrine, Lewis versus Reby is the case that would define if my client had a duty and the scope of that duty. The court was very clear in Lewis versus Reby in stating it's not a strict liability case, nor anything close to it. The facts in Lewis are very close to the facts of this case with a construction case, and in that case, the construction company in my client's situation had a contract with the owner that obligated him to provide overall safety. There's no such contract here. And the Lewis court said that the duty is coextensive with the liability and control. There has to be control. If their argument is we had no control, there is no duty and there is no breach. I see I'm just about 3 seconds left, and so I will end, and unless the court has any questions for me on those issues.
Thank you for your argument, counsel. We will adjourn. We will we'll take this matter under advisement and issue a decision in due course. Thank you.